Niranjan, I think I will.
Yeah, you,
Yeah,
you need to put in the
yeah,
perspective, sir.
that's right. Okay, thank you very much and welcome all the participants. And I hope that this particular session, which may not be appearing directly connected with the kind of engineering applications that we make, this may not be appearing directly connected, but the fact of the matter is that when we are going for execution of any of the projects, or for that matter, manufacturing or any other activity, handling the labor and understanding the labor laws is something which is extremely, extremely important. Why I would like all of you to basically be exposed to this particular thing, because the students that you are teaching, they are ultimately going to be working for the industry. And when they reach industry, at that point in time, it is very much expected that they ought to be knowing certain basics of the labor laws, and they must know that these are the things which they are going to be practicing in future. So this is an exposure that is being given to all of you. Try to kind of understand more, ask more questions, and try to kind of transfer this knowledge that you are gaining to your students also. That is more important for that matter. I definitely do need, once again, I'm repeating, 10 MCQs from each one of you must come. That is very, very essential and important for the completion and for the wellness of the program. And the second thing is that I can see that the number of participants is falling down very drastically, and everybody has to basically make sure that if for some reason you are not able to join the physical lectures, then you should be in a position to go through the recorded programs and then send 10 MCQs, failing which it will be difficult for us to issue the certification, the participation certificates, and the kind of acknowledgement of your participation. So take note of it, and please let your other colleagues also know who had joined this particular program. This is very, very important. Now I am handing it over to Professor Niranjan Swarup, who will be throwing light on the labor related things. And please listen to him carefully. This is going to be an interesting lecture. Thank you so much.
Sir, voice muted, sir. Sir, voice muted. Your voice.
I hope now it's fine.
Yes, sir. Yes, sir. Yes.
Yeah. Thank you for being part of this presentation. As Dr. Swarup indicated, you may feel that why this, but then the moment you go through the background, you'll realize where trying to take you. And believe you me, that's going to help our students extensively. So how do I start, change the slide? Is my slide visible?
Yes, sir.
Sir, first slide is sir title.
Slide,
Title is visible, sir.
my slide is visible. This is the second slide, visible?
Sir, yes, sir. Yes.
Yes, sir. Yes, sir. It's
Nice.
visible.
So now structured this into 6 parts: background, labor laws preamble, labor laws per se, brief description of the few important laws which are practically applied in India, then labor codes, and concluding remarks and the way forward, which I am presenting or proposing to all of you. So let's go to the background. Engineers provide techno-commercial inputs for industrial activities, may that be construction, may that be projects, may that be manufacturing, may that be trading, any of the work you talk. If an engineer is needed for that job, he or she would be providing techno-commercial inputs. Such inputs are used by the industry for successful operations. If the inputs are proper, they will be successful. If they are improper, the success would be suspect. Industrial operations invariably require labor inputs that are governed by the national, state, or local labor laws. Engineers, in providing inputs, require adequate understanding of applicable labor laws. Take, for an example, if you're talking about coding and you expect a coding or a coder to work for, say, 50 man hours, that would basically have to be translated from 50 man hours to the number of physical days, which would be governed by the labor law. And if he fails in calculating that particular impact, there is a possibility that the time allotted might be suspect or might be improper. And if that is the case, his inputs might not be usable. Armed with this understanding, the engineers would be able to render, engineers in providing inputs required adequate understanding of the applicable labor laws. So if I am engineer and I'm providing inputs for any kind of manufacturing activity, any kind of uh, computer activity, any kind of construction activity, electrical, mechanical, whatever branch I am, if I have adequate understanding of the applicable labor laws, I will be giving a holistic solution. On with such understanding, engineers would be able to render proper service to their employers. In case the engineer is unaware about the applicable labor laws, his employability quotient becomes extremely low, because if he does not know how to translate his design, his proposal, his project report into reality, he will have to go to somebody, and naturally his employability quotient will be extremely low. Educational institutions need to inculcate such knowledge bases in their students to enhance employability in them. In India, several laws are in force, and assuming that the boy or the girl will know by just going through the laws may not be very useful or may not be practical. The rules accompanying such law results into complex process for managing the labor works in activities and processes. The, there are in all about total 48 different laws governing the engagement of labor and uh, worker activities. Now, those 48 laws have been promulgated on different dates and different times, and every law has a different kind of definition for every activity, specific activity concerned in that law. And this basically means, end of the day, there are so many confusions and so many things which can complicate the whole understanding of the engineer, leading him to become, or rather providing some kind of input which is not very useful for the industry. In recent move, the Government of India has promulgated 4 labor codes subsuming different labor laws to simplify the process. The practitioner therefore needs to have adequate understanding of the core laws, and the current codes, or rather the promulgated codes which have been released something around 2020 for proper application. This talk aims to present the details about labor laws, recently promulgated codes, and the role of engineers in rendering technical services within the defined labor law framework. If you are having knowledge and understanding of this framework, you'll be able to provide your services in a better way. Objective is to encourage technical institutions and associated faculty members for inculcating these traits in their students for enhancing their employability. Mine and your basic objective. If my student gets proper employment, he is able to serve the industry with better outputs. Obviously, he will get a proper job, and if he gets a proper job, the industry grows as well as our institutions and our students grow. So this is what is the background, and now we will move to the basic preamble of labor laws. Why do we have labor laws? First of all, the labor laws are a body of laws, administrative rulings, and precedents which address the legal rights of and restrictions on working people and their organization. That is what generically could be termed labor laws. And as I mentioned, there are 48 laws, or there were 48 laws in force in India all those put together can be questioned as labor laws. The vision behind it is that such laws are created in line with the concerns of the government for the welfare and the protection of the labor and to endeavor to empower them and improve their quality of life. For an example, there is a nation, Iran, I would say. In Iran, Shell was operating the oil refinery plant there, and the labor laws were not at all enforced. And because of that, the people were literally living like destitutes who were working. They were working on a very long hours and all. Those things led to some kind of repercussions, some revolution, and many things happened. To contain that, laws were enforced so that people could get their dues. Increased productivity coupled with harmonious and peaceful labor relations and a new work culture only creates a conducive climate for rapid industrial investment and growth. This ensures the successful solutions to the twin problems of retrenchment of labor and creation of new jobs for unemployed. End of the day, the nation has to have people working and earning their livelihood so that the whole nation progresses. Government is also committed to providing labor market security, income security, and decent working conditions for the working population. Labor policy of government aims to carry forward these objectives. These aims can be attained only if there is a tripartite, mutually beneficial partnership between the employers, workers, and the government. I am presuming that most of your students are going to become a part of the employer or going to become the employers. So they need to see to it that the workers are comfortable, workers are able to produce as best as possible. And naturally, that will satisfy the government. If they fail to do that, the government would not be satisfied and they would be violating certain laws and rules promulgated by the government. Now, what would be the basic objectives of these laws? To ensure adequate safety measures and to promote the health and welfare of the workers employed in the factories, establishments, or temporary works even. The current code has gone up till temporary workers. Prevent haphazard growth of factories through the provisions related to the approval of plans before creation of a factory, basic minimum requirements for ensuring safety, health, and welfare of workers. So this is the primary objective. Further, there are two more objectives applicable to all workers. That is, anybody who's working in the industry or in the nation is has to be covered by the labor laws and the current codes which have been promulgated in 2020 cover everything. If you go on the Labor Ministry's website, you'll find that almost any and every worker is covered under these laws, applicable to all factories using power and employing 10 or more workers, and if not using power, employing 20 or more workers on any day in the preceding 12 months. So all these come under the basic objectives of any labor law which has been promulgated. Generally, if I look at the type of laws, there are two types. One concerning the individuals, the other concerning group of individuals. Individual means wages, working time, health and safety, anti-discrimination, all these. And collective means a group like a union, strikes, pickets, workplace involvement, andolan, all those things come under collective labor laws. So these are the two types of labor laws which are in practice. Primarily, if I look at the need is that the worker needs to get a specific amount of money for a unit time of work delivered, and that is what is the minimum wage. Examples of those are in India, Australia, Canada, China, France. The minimum wage is usually different from the lowest wage determined by the forces of supply and in a free market, and therefore works as a price floor. Though people might be dying of hunger, but if the minimum wage says that you have to pay him so much, it is expected that the worker will get this kind of money. In case if he is not getting it, then there is a law which is being violated. And if it is being violated, that basically means this person has all the right, all the authority to go and complain to the government or government agencies that his rights are being snatched away. So this basically functions as a floor on which your price is frozen. You can receive any money above that. So that's the minimum wages. The working time. The second thing is that you are allowed to work for a specific period of time so that you don't end up working 12 hours, 14 hours in a day. The standard timeline is about 8 hours, and for that 8 hours, there is a fixed amount of wage which has to be paid. So basic logic goes there. With the growth of industrialism and the introduction of machinery, longer hours become far more common, with 14 to 15 hours being norm. This was the old time. Then 8 hour movement came in, and since 1833, that 8 hour time was frozen. So basically, if my project requires, say, 48 man hours, that basically means this work requires 7 man days. Because if I'm talking about sorry, 56 man hours, so this basically requires 7 man days. So that will help me to evaluate my project work. Health and safety. Another set of labor laws involves safety of the concerning workers, and the earlier English factory law was drafted in 1802 and dealt with the safety and health of child textile worker. This got migrated into health and safety. Today we have the Health and Safety Code promulgated in 2020. So these basically define that these are the primary facilities I need to provide to my worker. The worker has to be given so much health protection, and that basically defines the effort, the cost, the infrastructure needed for that. And based on that effort, cost, and infrastructure, my engineer can evaluate that this is what the system he has to create if he has to run an office like this, run a factory like this, or run a project like this. That is what he can do if he knows that these are the minimum parameters and these are the input costs or input material requirements. Child labor, employment of children under the age determined by the law or custom that is defined. In India, you don't have any permission to allow any child workers. So my engineer has to know that what is the minimum age at which he can permit the person to come and work in his project. And that basically helps him to avoid some kind of duress to the child employed at the same time be within the legal framework to work and deliver the project. The child labor was not seen as a problem throughout most of the history, but now it has become a major movement. The strike. Strike is a weapon of workers decided on prescribed democratic process. It is for sympathetic works or basically anything where people or the workers do have objection to the management policies or the decisions or the infrastructure or material or anything. So that is a general strike, and certain categories of person generally are forbidden to strike. For an example, if somebody is working on essential services, they are covered under ESMA. Under ESMA, that is Essential Services Maintenance Act, they are not permitted to go on strike. But then we need to understand what requirements are there, and based on that, we can take our decisions or take our actions. Workplace involvement. The workplace consolidation statutes exist in many countries, requiring that the employers consult their worker on the issues that concern their place in the company. If a specific decision is being made which impacts the workers' well-being or workers' inputs or workers' gain or whatever, and the workers are not discussed, the issue is not discussed with the workers, there is a possibility that they may not be completely involved and they may be at the losing end. So the laws should look, or they look at workplace involvement. Then comes welfare of the workers. I need to provide them health security. I need to provide them education, that is them and their family. I need to provide recreational support to them. I need to provide housing for that, as the revised integrated housing schemes which are in vogue in India. Sickness benefits have to be given, maternity benefits have to be given, disablement benefits have to be given, dependency benefits have to be given. All these, if available to my worker, he would have the whole heart and soul in his work. If these are not available to him, he would simply try to vanish, he would simply try to go away from the work. But then, in case if these are not provided by law, I mean, they are not provided, the law will basically come and penalize the person or the individual or the institution which is involved in this. Say you have to provide health and you are not providing that. In that case, if somebody falls sick, the cost of that sickness and cost of the health gain has to be borne by somebody. Now the employer needs to be the concerned person. So these things are part of the basic legal framework. And I do not say that he has to go all the way up to the end of the world, but at least he should know what are the limits for which he has to provide these things for his workers. Then comes the labor policies, or basically different combination of these rules or these laws, and that is what uh, were in force till very recently. They are still in force, but now they have been subsumed and four codes have been prepared. I've concluded my philosophy part of the labor laws. Now I'm going to the basic labor laws which are for force. So, what are the basic labor laws? Let me just give you a list. This list starts from Trade Union Act 1926, Industrial Employment Standing Orders Act 1946, Industrial Disputes Act 1947, Payment of Wages Act 1936, Payment of Bonus Act 1965, Working Journalist Fixation of Rates of Wages Act 1958, Factories Act 1948, Plantation Labor Act 1951, Mines Act 1952, Sales Promotion Employees, the Condition of Services Act 1976, Working Journalist and Other Newspaper Employees, Conditions of Services and Miscellaneous Provisions Act 1955, Interstate Migrant Workmen, Regulation and Employment and Conditions of Service Act 1979, Dock Workers Safety, Health and Welfare Act 1986, Building and Other Construction Workers Regulation of Employment and Conditions of Service Act 1996, Cine Workers and Cinema Theatres Workers Regulation of Employment Act 1981, Dangerous Machines Regulation Act 1986-83, Merchant Shipping Act 1958, Motor Transport Workers Act 1961, Beedi and Cigar Workers Conditions of Employment Act 1966, Mines and Minerals Development and Regulation Act 1957, Private Security Agencies Regulation Act 205, Dock Workers Regulation of Employment Act 1948, Dock Workers Regulation of Employment, Implicability to Major Ports Act 1997, Employment of Manual Scavengers and Construction of Dry Latrines Prohibition Act 1993, Maternity Benefit Act 1961, Equal Remuneration Act 1976, Bonded Labor System Act, Abolition Act 1976, Children and Adolescent Labor Prohibition and Regulation Act 1986, the Sexual Harassment of Women in Workplace Prevention, Prohibition and Redressal Act 2013, Apprentice Act 1961, Employment Exchanges Compulsory Notification of Vacancies Act 1959, Employees Compensation Act 1923, Employees State Insurance Act 1948, Employees Provident Fund and Miscellaneous Provisions Act 1952, Payment of Gratuity Act 1972, Employers Liability Act 1938, Fatal Accidents Act 1855, Limestone and Dolomite Labor Welfare Fluid Fund Act 1972, Mica Mines Labor Welfare Fund Act 1946, Iron Ore Mines, Manganese Ore Mines and Chrome Ore Mines Labor Welfare Cess Act 1976, Iron Ore Mines, Manganese Ore Mines and Chrome Ore Mines Labor Welfare Fund Act 1976, Personal Injuries Compensation Insurance Act 1963, Personal Injuries Emergency Provisions Act 1962, Unorganized Workers Social Security Act 2008, Beedi Worker Welfare Cess Act 1976, Beedi Worker Cess Welfare Fund Act 1976, Cine Worker Welfare Cess Act 1981, and Cine Workers Welfare Fund Act 1981. Now, my point to read out all these names is that Each of these acts define certain parameters, and those parameters basically at times go against each other. And this basically creates a lot of confusion and a lot of difficulties for the practicing engineers, practicing professionals who have to double as a management or as a legal person also. Believe you me, all your students will have to function as a management and a legal person very soon. And if they have to they have to act like that very soon. They need to understand they need to have the basic information and understanding about these acts, these laws, and these laws details can be uh, assimilated, collected from the net or from the legal bookshops or the books. You would be really helping these boys and girls to go forward. But then these things have been kind of subsumed and a common code has been created so that the confusions and other things are contained. Before I go to the codes, I would be simply explaining some of the provisions of the major acts which play a role in almost everybody's life. As a brief description of few important laws. Minimum Wages Act 1948. The objective is to determine the minimum wages in industry and trade where the labor organizations are non-existent or ineffective. Let's say you are talking about the unorganized sector like a construction, construction project, construction work. In construction work, there is nobody to define what would be or what should be the wage. In that case, the Minimum Wage Act comes into the picture and they say that this is the minimum wage in this state and that either promulgated by the different states in their area. So anybody using services of personnel for construction work have to pay as per the minimum wages identified in the act or rather in the declaration of the state. The scope and coverage includes application applicable to all employees engaged to do any work, skilled, unskilled, manual, clerical, in a scheduled employment, including outworkers. The main provisions are fixation of minimum wage for employees, procedure for fixing and revising the minimum wages, and rights of workers. So these were covered in Minimum Wages Act. Another one is Employees State Insurance Act 1948. The objective here is to provide health cover, medical care, and cash benefits for sickness, maternity, employment injury, or pensions to dependent in case of death or employment injury. Eligibility is open to employees drawing wages not exceeding 3,000. This was ESI Act of 1948. The values have changed depending on the time or depending on the changes of the minimum wages. The compensation for death ranges between 20,000 to 1,14,000. The compensation for permanent disablement ranges between 24,000 to 70,000. These values are also revised. Employees Provident Fund and Miscellaneous Provisions Act 1952. Here the objective is to make provisions for the future of the industrial worker after he retires or for his dependents in case of his early death. It includes compulsory provident fund, family pension, deposit links insurance. The scope and coverage is that it is applicable to factories and establishment employees 20 or more persons. Application applicable to all persons who are employed directly or indirectly through contractors in any kind of work. So this particular act also had or also has a major implication that let's say if your project employs say 500 workers, 1,000 workers, everybody's provident fund has to be collected and deposited. When we are talking about the migrant workers, there are challenges about how do you have those provident fund deposited because the provident fund belongs to the person for whom the provident fund was deposited. But then that person is not listed or not in a proper database. So later, if he requires that money, he will never get it. So those monies get accumulated. And to cover that up or to control that, there are codes which have been promulgated now. We'll go to that. Let's look at the few more important acts. Equal Remuneration Act 1976. Payment of equal remuneration to men and women workers for same or similar nature of work is protected under this act. No discrimination permissible in recruitment and service conditions except where the employment of women is prohibited or restricted by law, or any other rules. The Trade Unions Act. The objective is to confer a legal and corporate status on the registered trade unions. Scope and coverage includes applicable to unions of workers as well as associations of employers in the whole of India. A central legislation but administered and enforced by the state government. And the main provisions include it defines what is a trade union, registration of a trade union by any 7 or 9 workers by seven or nine workers of an establishment on applying with a copy of the rules of the union, the name and address and list of the office bearers. The obligations and rights of the registered trade unions are basic provisions of this act. Workman Compensation Act 1923. The objective is to provide compensation for workmen in case of industrial accidents, accidental occupational diseases, in the course of employment resulting in disablement or death, coverage for persons employed in factories, mines, plantations, the railways, and other mentioned in Schedule 2 of the Act. The benefit is for the death, the range is from 20,000 to 1,14,000. Compensation for permanent disablement ranges between 24,000 to 70,000. For temporary disablement, it is 50% of the wages for the maximum period of 5 years. So these are the compensation values which are paid if the worker faces some kind of accident or some kind of industrial difficulty. Now comes the labor code. One thing which you have seen or which I have narrated was 48 names very fast. The reason was to let you know that for the same kind of work there could be more than one act applicable. That complicated the whole situation. So the need was to subsume the similar codes and bring them to one platform. And that is what the labor codes did. And in 2020, and specifically the wage was started in 2019, the government of India promulgated 4 new labor codes, which are basically for industrial relation codes 2020, Code on Occupational Safety, Health and Working Conditions, Code 2020, Social Security Code 2020, and Wage Code 2020 and 2019. These codes came with the government policy. We need to understand the government policy so that the basic logic behind it is understood, and based on that understanding, we can take our decisions or take further action. What are the labor policy the government has? The highlights are it is aimed at creative measures to attract public and private investment, 15 lakh new jobs in the coming 5 years, a unified and consolidated legislation for social security schemes, new social security schemes for workers in the unorganized sectors, social security cards for the workers, unified and beneficial management of funds of welfare boards, reprioritization of allocations of funds to benefit vulnerable workers, model employee-employer relationship. Welfare board, if you are not aware, welfare board do collect the cess of the construction cess if we are talking about the construction workers. And there are substantial amount of monies which are parked there, which is not being deployed for proper benefit of the construction workers. So the policy aimed at bringing all that management in a proper fashion. The next set of labor policy highlight include the long-term settlement based on productivity, vital industries and establishment declared as public utilities, special conciliation mechanism for project with investments of 150 crores or more, industrial relations committee in more sectors, labor law reforms in tune with the times, empowered body of experts to suggest required changes, referenda for recognition of trade unions, statutory amendments for expediting and streamlining the mechanism of labor judiciary, amendments to Industrial Disputes Act in tune with the times, efficient functioning of the Labor Department, more labor sectors under Minimum Wages Act, Child Labor Act to be aggressively enforced, modern medical facilities for workers, rehabilitation packages for displaced workers, restructuring of functioning of employment exchanges, computerization of updating of database, revamping of curriculum and course content in the industrial training, and here comes your role as well. Joint cell of Labor Department and Industries Department to study changes in the laws and rules. Kerala Institute of Labor and Employment to be upgraded. Policy progress monitoring team to review progress of the implementation policy. So all this is part of the policy of the government, and based on that policy, the codification was done, and this codification had these 7 benefits. It facilitated the implementation, because if you have Minimum Wages Act and Employees Compensation Act or some other act, there would be some kind of mix-up. So how do you implement them? Removal of multiplicity of definitions. One act defines something, the other act defines something else. Minimum wage in one act would be some value, another act some other value. If you bring them together and bring them on normalcy, you reach some standard valuation. Facilitate the use of technology. If I'm talking about the Provident Fund of Workers, and those Provident Fund monies are deposited with the Provident Fund Commissioner, the person who has an Aadhaar card, the person who has some identity, and the money is deposited in, through that identity, would have the capability to draw that money. And that basically helps in finding the rightful owner of the monies. So basically, use of technology helps in a major way. Ensure transparency and accountability, aid in effective enforcement of provisions, facilitate ease of compliance. All this come into force. I would be talking about these 4 codes, and I will be sharing the government gadget for that with all of you. These gadgets need to be shared with your students so that at least they should understand these codes properly, and they may go or they should go to the code acts behind them, and based on the basis of that, their understanding will be much better than what is today. Or rather, the students who graduate from your institutions, if they are not exposed to these things, they would not know what is actually expected out of them. First is Industrial Relation Code 2020. A copy of this would be shared to you once of my presentation is over. Industrial Relations Code 2020 provides a new concept for negotiating the trade unions or negotiating councils in an industrial company. According to the stated provision, in the case of a single union in an industrial company, the employer recognizes that union as the sole bargaining union of the workers. In case if there are multiple, the employer recognizes them. There were cases where employers were not recognizing the union. So basically, that led to lockouts, that led to strikes or whatever. To contain that, this particular code has been implemented, and it consolidates 3 enactments related to industrial relations. So by consolidating that, you are reaching a position where the workers or the unions are in a proper harmonious relationship with their employers. The next code is Code on Social Security. Unfortunately, in India, the industrial workers, construction workers, or even let's say the office workers are not provided much security net. And if the security net is not there, and they by some chance lose their job, take for example the COVID epidemic. In this case, many people lost their jobs, and what happened? They do not have any kind of backup support. For that, a social security net is required, and that net is being proposed or being promulgated through the Code on Social Security. The code was introduced to provide social security benefits by extending its goals to employers and employees. The code seeks to simplify labor laws by amalgamating various enactments such as the Employees Compensation Act, the Employees State Insurance Act, all those put together. In totality, it consolidates 9 different statutes. So all those where the confusion was coming in, they were contained, or they are contained in this. The next code what we have is Code on Wages. It was promulgated in 2019, and the rules were created in 2021. Based on these two, the point is the new wage code is about to reach its stage of completion by the central government and will be implemented in this financial year. Many changes have been made under this bill regarding holidays, salary, working hours of the employees. It subsumes 4 legislations concerning wage rates, time and payment and bonus. The next is Occupational Safety, Health and Working Conditions Code 2020. The Occupational Safety, Health and Working Conditions Code 2020 is a code to consolidate and amend the laws regulating the occupational safety and health and working conditions of the persons employed in an establishment. The Act replaces 13 old central labor laws. And this particular law basically helps in making, providing proper occupational health to the workers. Now, if my engineer does not know what are the stipulations for the OSHA or the Occupational Safety and Health Act, although if he is not aware, then he might be ending up in some kind of accident, some kind of poor working environment, and that has to be contained. As professors, as teachers, it's your business, and as CIDC, it's my business to see to it that my boys and girls know about these particular codes and start applying them in their business. So, what is needed? The need is the engineers need to have the basic understanding of labor laws and the philosophy behind those. Sensitization about the 48 laws, that what is the genesis of these codes. Proper understanding of the main laws applicable to the line of profession. Understanding about the basic philosophy of the government and the labor policy. Detailed understanding about the labor codes promulgated recently. Understanding about the role of laws and codes in the project's activities and their application protocols. Say you are talking about writing a code for some software project. There are standard documentation on the labor requirements or on the rights of labor, confidentiality, and all those things put together. All those are covered, all those have to be addressed by you. If I don't look at, as an engineer, if I don't know this, my action would be that whatever the fine print is, I will simply say, I agree. No, you should not. Your students should not. They should know what is actually written in that agreement. When you are buying a software, there's a long list of applications or long list of rules. Those rules you agree, only then the software starts performing. You need to understand that is quite important, that he should be able to read and know that what is legal, what is not legal. Based on that, he can take an action. This I talked about a software project. If I talk about a construction project, it's very well known all these things play a major role. If I talk about manufacturing units, in manufacturing unit, there are Factories Act and all those things. All those also have been subsumed here. Once they come in, those laws and rules have to be understood by my boy so that he is ready to function, to deliver from the day one, the day he passes out from my college. So that is what is the knowledge base I need. And what I need from my faculty members, my partner institutions, engineering institutions, in induction of sensitization activities in regular about labor laws and their applicability for students, collection and assimilation of inputs about the labor law, sensitization workshops to be conducted, student lead webinars for spreading the knowledge to more students, interaction of students with the industry seniors, institutional alumni for cultivating knowledge bases. Stakeholders could network with us for building these capabilities and networks. So with this, I would thank you for patient hearing and conclude my presentation. Thank you very much. A copy of this presentation and those codes shall be shared with you once we complete the program. So, do we have some discussion, some point to talk?
Hello, sir.
Dr. Gandhi.
Hello, sir. I am Satish Gandhi from University College, Nagarkoil. Sir, I am audible?
Yes, you are.
Yes, sir. Sir, if one of the employee get the agreement with the concern, they are asking to pay the 3 month salary, basic pay of 3 month salary,
Mhm.
if they want to leave the job.
Mhm.
If the candidate if the employee is ready to pay the 3 months basic salary,
Mhm.
but the concern is asking the total HRA and everything they are included and ask them to pay for 3 months.
Mhm.
If I go to the labor law,
Mhm.
labor court, shall I put file for this labor law?
No. See, if you look at the code on wages, code on wages, they have defined the composition of the salary. That this component forms a part of the salary or wages or whatever, and that is very clearly written. All you have to see if it is matching with the company's stated requirement. If company says that I will take the HRA, I will take the medical, I will take your conveyance allowance as also as a part of the security deposit, that may or may not be in line with the labor code, which is wage code, which has been promulgated in 2019 and 2021. The rules have been framed. I'm sharing both the documents with you. Okay, so this should be known by your student, whoever is getting this job. So that these are the parameters, legal parameters. Now, if he agrees to still pay that money, no problem, no issue, because that would be an understanding between this person and the employer. In case if he has any objections, then he can take the help of the law. That is what is the point.
Okay, sir.
See, my intent, this is something which also comes into play because all the students will go for some job and they have to be aware, that these are the conditions facing them. But then my larger interest is that they should be knowing how their works are going to happen. If they are going to work in a supply chain system, so their supply chain management activities need to address these laws. Okay. Dr. Jayalakshmi, you were saying something.
No, sir. All the points explained by you is clear, sir.
Nice. So you will be initiating the workshops on labor law? Would you be? Dr. Jayalakshmi,
Yes, sir.
you would be initiating these workshops in your college?
Yes, sir. Yes.
See, these could be extracurricular webinars or talks in which you can assign the boys and girls to kind of search the net, go to the legal documentation, go to the books, create presentations and share them.
Yes.
Talk about applicability of labor laws in software industry. Talk about applicability of labor laws in manufacturing industry.
Yes, sir.
We can do anything, and that basically helps my students to learn and cultivate that kind of prowess or understanding of the business.
Yes, sir. Yes. Fine. Sir.
So, in case if this is, and there are no further questions or no point to be discussed. I think Dr. Sunita Dhotre, you want to say something? Dr. Sunita? All good, I believe. So After this presentation, I hope you will be able to create 10 objective questions from your end.
Yes, sir, we will do, sir.
Yes. Please see to it that this helps your students in a larger way. And if you desire, you should share this presentation with your students as well, so that they can take items from this, go and find more inputs on the net or some other place and work out. So, okay, I would conclude the presentation today. Thank you very much for the patient hearing, and we may disconnect now.
ही टेस्टर्स कि क्या हम लोग सबसे बड़ी बात कुछ कर सकते, इतनी सैलरी देते हैं क्या कि इन लोग टाइम पे भी ना दे पाए? ऐसे तो नहीं देते हम लोग को कुछ भी।
आप 5 करोड़ का जिम बना लीजिए, इस चीज के तो ऐसे जो 5 करोड़ आप इन्वेस्ट कर रहे हो, हमको जगह पे 50 लाख आपका कोई इन्वेस्टर लेके भाग गया,
हाँ वो हमारी गलती
एक साल में जाग रहे हो,
वो भी हम ही से वसूला जाएगा।
उससे हमसे
अब नहीं सर, ऐसी तो होता है सर, नहीं बात कर थोड़ी है। तुम उसमें घूमो, रेंज रोवर में घूमो, तुम 10 करोड़ का जिम बना दी, हमको हमारी फीस दे दो, बस खत्म करो। तुम अपना गेम दियो,
एक्चुअली ना ये जगह सुनने के पहले आपको कैसे सुनने ये सत्ता में का जो बीच है, और फिर अपना बारे में जो सागर ऐसे जो ये है ना, इन लोग नहीं है ना, थे कभी ना है
नहीं उन लोग तो जीरो एडमिशन,
पता नहीं कैसे मेंटेन करके चल रहा है। इवन मेरा जो हमसे किया ना अभिषेक साहू,
एक बच्चे नहीं है, उन लोग फिर भी 70% सैलरी दे रहे हैं।
हमारे स्टूडेंट अभिषेक वर्मा उनसे 55,000 पा रहे हैं, हम 45 में 55 पा रहे हैं।
ये बीआईटी वाला,
हाँ
बीआईटी में हमेशा टाइम टू टाइम इंक्रीमेंट होता है।
स्टूडेंट्स है ना, वो लोग उनसे ज्यादा।
हाँ तो ही है मैडम।
ट्रिपल का स्टूडेंट है अभिषेक वर्मा, यही
नौशीन वगैरह का लेवल तो जान ही नहीं है।
क्या अभिषेक का कौन सा लेवल है?
उनका लेवल तो जान रहे हो।
अरे अभिषेक को हम जानते हैं ना, अभिषेक का कौन सा लेवल है जिसके बारे में बोल रहे हैं?
अभिषेक वर्मा
कौन सा लेवल है?
क्योंकि वहाँ पर नियम है ना, इतना बढ़ना ही है हर साल।
मैडम मैं मैथ्स में 2 लड़की 2 साल पहले ज्वाइन की,
सारा नियम वहाँ का, पढ़ाई लिखाई का, हाँ कॉन्फ्रेंसेस का,
नहीं
बाकी चीजों का,
पढ़ाई लिखाई का नहीं है मैडम,
सब चीज।
वहाँ हम
उन्हें बच्चों के माँ बाप भी गाली दें हमको, मतलब हम क्या है?
Jacket one is